Sorry if I'm juggling around. I'm just trying to get a picture because I'm at 800 Broadway. Not my normal space.
Good afternoon, everybody. Welcome to the First District Court of Appeals. If everybody could just introduce yourselves and tell us who you represent, that would be helpful for us.
Good morning, Your Honors. My name is James Anselmo. I am counsel for the mother, the appellant.
Okay, thank you.
My name's Donita Parrish, and I am the guardian ad litem for the children.
Okay.
I'm Cynthia Doherty, and I'm the Henry Williams attorney for the Smith girls only.
And are you going to share argument time with Ms. Parrish?
I can, Your Honor. That would be perfectly fine. I have maybe 5 minutes.
Okay.
And that's fine with me.
Okay. All right. Mr. Anselmo, would you like to reserve any rebuttal time?
Yes, Your Honor, if I may reserve 5 minutes.
Sure. All right, you may begin when you're ready.
Thank you, and may it please the court and opposing counsel. My name is James Anselmo, and I do represent the mother in this matter. I'll primarily rely a lot on what I stated in my brief, but just highlight a few points if I may. As I mentioned in the brief, it does appear that the court in this matter granted permanent custody to children's services on grounds that it was concerned about the mother not taking an accusation of sex abuse against one of the children seriously, and the fact that the court was concerned that the mother may allow the sexual abuser to actually have contact with the children again. It's my understanding that this sexual abuser was the mother's ex-husband. She did testify that she would not allow this abuser to be around the children. In fact, she testified she had plans that she was going to leave the county. She was wanting to find a nicer area to live in, and that she indicated that this would most likely be leaving the county, and then for physically separating from this individual. And she has divorced this sexual abuser. I know there was some confusion she had earlier. She mentioned she had a
wasn't there some evidence in the record to cast doubt on kind of what she was saying about all of that?
I know she did say, Your Honor, I know there was some evidence brought up against this matter where she expressed a desire to have shared parenting with the sexual abuser while she was going through the divorce process. But she clarified that she did not fully understand this. And again, I guess I can only go back to the fact that she testified under oath that she would not allow the children to be around this individual, and that she did not actually favor shared parenting once she understood that term. I think also, going to the fact that she may have doubted the sex abuse earlier. She did go through parenting classes in a PACT program where it sounds like she was able to understand the seriousness of allegations and maybe the trigger points of what to look for. And she indicated that having gone through this, she educated herself on how to deal with children who went through trauma. Yes, sure.
Mr. Anselmo, Judge Bach has a question for you.
Counsel, as far as timing, how long before the hearing did she come to the realization that shared parenting wasn't a good idea and that she started believing the allegation?
I think I understood your question. It kind of froze a little bit on me. I'm not exactly clear, Your Honor. It does appear that during the process of the divorce proceedings, I mean, she later came to that realization. Unfortunately, I don't have a specific answer for you on that. But it appears to me, I would say it was, she's not just making this up at the hearing and saying this stuff at the hearing, that, you know, these classes and these proceedings did occur beforehand. And then that's when she came to these realizations of the importance of understanding the nature of the allegations. Unfortunately, Your Honor, at this point, I can't recall specifically the timeline of that. I guess I would also just note that pardon me. So she did indicate that she felt that the visits with her children were going well, that the children enjoyed them. There was some concern that the child that was abused had hesitations with the visit. Then again, this was before the mother completed the parenting classes and the PAC program. And she's now, and also these hesitations were before the divorce was finalized. And she testified that she's now in a better position to parent the abused child as well as the other children.
But didn't the children express a preference to not go back to her, to stay with, I believe it was Ms. Thompson?
Yes, that's my understanding. But I guess, Your Honor, at the, really, this court needs to look at the best interests of the children and also, I would argue we have parental rights at stake. So, obviously looking to see if it's in the best interest of the children, that they be returned to the mother. And I would fall back on the fact, though, that you have the mother testifying that she thought the visits went well. She indicated they seemed happy and engaged when these visits were taking place. And yes, there were some difficulties earlier on, but that was, again, before this divorce was finalized and before the mother took these parenting classes. Obviously the wishes of the children are one factor, but overall, looking at the best interest factors, I would go back to the fact that we have someone who testified she's gainfully employed, looking to better herself and finding a better place, in an area to raise her kids. She separated herself from this abused individual, and also she's taken parenting classes, gone through therapy. It seems like she's done everything she can to create a safe environment for these children. And I would argue that the best interest factor would actually be in favor of reunification. I think there was some testimony too where the current caregiver indicated she may not be able to care for all the children much longer. I think obviously that would vote in favor of some doubts of the current custodial arrangement.
Let me ask you, sir.
And if there's no other questions, I would yield the rest of my time.
Yeah, I do have a question for you. You said that mother separated from this individual that's been described as a sexual abuser, but it seems like the court seized on that, and there were concerns that she was still having contact with this individual very close in time to when the hearing was conducted. Did I misinterpret that, or is that the case, sir?
No, that may be so. I'm trying to refresh my on that, but I think though, I guess I think it's significant though that she has started, I mean, she did go through a divorce proceeding. She did testify that she's planning to leave the area, leave the county, physically separate from this individual, you know, and that she did step up to sever the marital relationship she had with this individual. And I guess I would argue that those would mitigate against any concerns that the trial court had.
Counsel, wasn't there evidence in the record that the reason she initiated the divorce was because he left?
Yes, I know that there was some. Yes, I know that there was some indications of that. Yeah, until he engaged into a new relationship. But I guess again, Your Honor, I would, you know, I would go back to the fact though that, you know, with that she didn't, you know, she did take that initiative to separate the marriage, and to allow this marriage to terminate, and she didn't go through any action to reunify with this individual, and take him back, if you will, or try to amend it. I mean, she allowed the divorce proceedings to go on, and that with, you know, her own testimony where she, you know, she indicated, yes, she does need to separate from this individual, and is even looking to physically separate.
Thank you, Mr. Anselmo. Ms. Parrish?
You're on mute. Ms. Parrish, you're on mute.
You're on mute, Ms. Parrish.
I'm sorry, I believe that Ms. Doherty was going to present first.
Oh, okay. I'm sorry. Ms. Doherty?
Oh, yes. Can you hear me okay?
Yes.
Okay, great. I represent the Smith girls who, it was their their half sister that was the victim of Mr. Smith's sexual abuse as far as children. Mother was married to Mr. Smith, that was true, but even though she knew that he had a history of sexual abuse, even prior to the Lindsay child. Mr. Smith, he did have a history of sexual abuse of the half sister and the Smith children, and mother continued to deny the reports and disclosures and the physical examination, physical evidence of this physical sexual abuse to one of the Lindsay children. Mother was ordered to attend the counseling, I believe, on 3 separate occasions. Every time we came back to court, the mother was then ordered again to go to the PAC. And she just delayed that and delayed it because she continued to deny that Mr. Smith was guilty or could have done that. She reported continually that she was no longer involved with Mr. Smith, but the agency was able to show that Mr. Smith was not only still around, but the caseworker, I believe in the testimony, reported that even when she went to the home of mother, that she saw Mr. Smith there. So he was also living in the home. And there are, if the timeline plays out, mother's reports of when she actually stopped being engaged with Mr. Smith doesn't add up to when she said he actually moved. She actually reports that he moved out much later. Mother has chosen to be with and believe Mr. Smith over her own daughter. And in doing so, mother was not able, during the course of this court involvement, to gain an understanding of the effects of the sexual abuse on her daughter. And therefore, she could not engage in services to help heal the family, heal the daughter. And this can be shown in the records, admitted in the records were these central clinic therapy sessions of mother. And I think we dove into that pretty intensively at trial.
Ma'am, may I stop you there?
Yes.
I did see that in your brief, and I know you did go in depth into the central clinic records at the trial, but in your brief at page 7, it says they were admitted as Mother's Exhibit 1. Are you sure they were admitted? And the reason I'm asking the question is, I know this was set in short order, and do you believe the court admitted those exhibits.
I believe they did. I think the parties stipulated because I remember being handed a very large packet from the Central Clinic from Mother's attorney at the trial date. And actually, had it not been for the fact that I was last in cross-examining Mother, I don't think I would have ever been able to be allowed to have the time to go through those records. So I believe before that case started, and maybe Ms. Parrish can speak to that as well, we all stipulated to the admission of those records, that mom attended the Central Clinic and that those were the records. And I believe that was Mr. Capsule who requested that. And we stipulated to the admission of that. Does that answer your question?
Yes.
And then, so I think in those records, it shows mom's focus, and that all through her therapy, her extensive notes in those records, that mother's focus was on housing. It was on the community violence where she lived. I think there was some, interest in her leaving the community. However, within a time frame of 6 years, she's never really done anything substantive to leave the community. She even testified that it's not an area where that children should be or live. She also complained in her therapy notes about the Duke bill and that not getting paid. Is it on? Is it off? About money. But at one point, she actually asked the therapist, after she had reported that she was no longer involved with Mr. Smith, she had asked the therapist if she was allowed to have sex with him. So that clearly states in those records that she's still wanting to be engaged with him. She asked that question even knowing after she said she started to believe that the daughter's story and the sexual abuse against her own daughter. So there was, little or no focus in any of those records on the children and the effects of abuse upon the children, or on her daughter's recovery, yielding little or no protective capacity, in my opinion. So both the Smith girls are requesting that this court uphold the juvenile court's decision granting permanent custody to the agency and terminating mother's parental rights. Thank you, Your Honors.
Thank you. Ms. Parrish?
Thank you, Your Honors. And first, I would like to address the question of the Central Clinic records. I was not the guardian ad litem at the time of the trial, but I did review the trial transcript. And at the beginning of the first date of trial, there were stipulations by Mr. Capsule at Mr. Capsule's request to admit those records. Also, mother's testimony at trial was that she had spent the majority of the time in counseling talking about whether or not she should continue her relationship with the man who abused her daughter, whether about her housing issues, about her concerns about her neighborhood. Despite the fact that mother acknowledged that Mr. Smith had sexually abused her granddaughter, she continued to disbelieve that he had sexually abused her daughter, even when her daughter was uncomfortable and would not visit her because she continued that relationship. This is an unfortunate case in which the mother testified, and there was evidence presented that the mother had also suffered sexual abuse as a child, that the reaction from her family to the fact that she was sexually abused was not appropriate, was disbelief, and she was not protected. Unfortunately, that experience of hers seems to have made it harder for her to take the right action and protect her child in a similar situation.
Ms. Parrish, what about, there was a comment by Mr. Anselmo about the Thompsons maybe not being able to adopt. I thought I read something on the record that they were inclined to adopt.
They are inclined to adopt. The children have been in the home for about 2 years. The current kinship caregiver is a relative of the older children, and they are functioning as the children are together. They are doing well, functioning as a family unit. And she is interested, willing, and waiting to adopt them. So while the children have been in their current kinship placement, their needs have been met, their educational needs, their mental health needs have been met, and they have been supported. They have all expressed a desire to stay in their current placement. Mother acknowledged that the child who was abused did not want to visit her because of the disbelief that she had, that mother did not believe that she was sexually abused. And mother acknowledged that her behavior had hurt her daughter. Mother acknowledged that the older son did not always want to visit and sometimes chose other activities over visiting with her. Unfortunately, this is a situation where mother just was not up to the challenge of dealing with this situation appropriately and was not able to protect her children. And these children deserve to have permanency, to be safe in a home where they can be protected. They came into the home that they're currently in March of 2018. So have been in that home for approximately, all four of the children have been in that home for approximately 2 years and out of mother's care for 3 years, since January of 2018. These kids need permanency. There was sufficient evidence for the court to make the decision that it did. And while mother testified that she believed her daughter, that she had changed her mind, that she was going to behave differently in the future, the trial court was able to weigh the evidence that was presented, was able to assess the demeanor and the credibility of witnesses, and based on that assessment and those judgments, made the decision that it was in the best interest of the children that parental rights be terminated. And this is a situation where the children were also abandoned by their father. They need to be in a place where their needs are primary, and that's the current placement that they're in. So I ask that the court uphold the decision of the juvenile court.
All right, thank you, Ms. Parrish. Mr. Anselmo, you have a rebuttal time. And you're on mute. Mr. Anselmo, you're still on mute.
Okay, is that better?
That's much better.
Better? Oh, okay, thank you, Your Honor. Apologize. I would say that if I recall in the transcript, November 11th, 2019 transcript at 150, current caregiver indicates she may not be able to care for all the children much longer. But at any rate, and there was acknowledgement of the complexity of this situation. The mother, obviously had some history herself with sex abuse. And I think that trial counsel did a good job, for the mother did a good job of arguing this point too, the fact that you have a situation where the mother's just being bombarded with all these allegations of sex abuse, marriage falling apart. This is a lot emotionally to take in and deal with and process. But at the end of the day, she does go through therapy. She does come to a realization that she needed to get away from this individual. She actually testified that she wants to leave the county to a safer area that would physically move away from this individual, and that she understands the need for no contact there. I don't think this is a situation where past is prologue. I think this is a situation where the court should look at her actions. In eventually going through the therapy, processing all of this, and emotionally coming to terms with the reality that yes, she needs to get away from this individual. She needs to believe these allegations, and she needs to create safe spaces for her children. So with that, I would ask the court to consider the testimony in that light, that she testified under oath, and the actions that she did take to rectify all this and to create safe spaces. That with the testimony that she did testify that she thought the visits went well with the children. So I would ask this court to consider all that, and considering that the evidence does not favor parental termination, and would actually indicate that a reversal is mandated.
Thank you, Mr. Anselmo, and thank you, counsel, for your arguments today. The case will be submitted. We'll get out a timely written decision, and we hope you all have a great day.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you.